general civil matter before we get to Mr. Rognus's landlord-tenant case. This is an interesting case, and this comes up from time to time. I talk with my clerks. These 145 hearings are always like fingernails on a chalkboard in the middle of a landlord-tenant day. But this one has to do with a garnishment. This is file number 18951. It's entitled Sturgis Hospital versus Kathy Doyle. Attorney Robert Goodman is here on behalf of Sturgis Hospital.
Good afternoon, Your Honor.
Good afternoon. There was a fairly substantial claim. I'm going to bring our next person in, Mama D here. Ms. Carter, can you hear me?
Yes, Your Honor, I can.
All right, we're working on another case. Mr. Rognus is here and Meg Bauer is here from Legal Aid, but let me finish the case I'm on.
Okay.
All right, this is an old paper file, and I'm not sure it's not all here, but the hospital sued this defendant for this amount of money. I believe it entered by default. Yes, June 29th of 2018, they got a judgment for $6,380. These judgments are good for 10 years, and they can actually be renewed for another 10 years. They filed a garnishment on her bank account, and they seized the entire amount from a bank account at Sturgis Bank and Trust, which would satisfy the debt. Ms. Doyle says, wait a minute, I don't have that kind of money. They must have seized my mother's account. And when you put your name on your mother's account, that becomes garnishable. And that's a harsh lesson that people find out the hard way. So apparently your name was placed on your mother's account, and that becomes subject to garnishment, and the bank suddenly remits payment, and they're finally able to collect on this 7-year-old judgment. Mr. Goodman and his law firm, who actually signed the pleadings, he did, my guess, says that money is subject to garnishment. And in addition, the person who has standing to object to it is your mother, not you. If you're saying it's not my money, it's my mother's money, your mother has standing to object. Mr. Goodman, you wish to expand on your response?
Judge, I think you've given a good summary of our argument. I would simply add that the applicable court rule is MCR 3101K, and it provides that an objection to garnishment is limited to the items listed on K2, and those are that the funds are exempt, the garnishment is precluded by the pendency of a bankruptcy, barred by an installment order, there's a higher priority writ. There's the arguments that Ms. Doyle has made here are not one of the enumerated permitted objections to garnishment. And then we also did provide for the court at number 12 in our response, the applicable statute, which clearly does indicate that the bank account is subject to the efforts of a creditor. And so for those reasons, and then lastly, she's done nothing to establish. I mean, she indicates that this was her mother's money, but I have not seen any documentary support or anything showing the source of these funds from Ms. Doyle.
Ms. Doyle, this is the only time this has ever happened to you. Mr. Goodman and his company do collection work, and this kind of thing probably comes up for him a dozen times a year. Excuse me, I'm about to sneeze.
Bless you.
And it comes up for me periodically also. Once the money is commingled, you're right, there's nothing that we know other than what it says in your letter that it's your mother's money. All they know is this is a bank account with your name on it, which has $6,565.53 in it, and they've seized it. So that's the first issue. Secondly, even if it is your mother's money, once you put your name on the account and commingle it, it becomes subject to garnishment. He cited the authority for that. And third, the person that would have reason to object would be your mother, not you. So what's your response?
I wasn't aware that my mother could object because it was in mine, the judgment was against me. I completely understand what you're saying. I do owe the money. I don't deny that. I can show documents. The only money that goes into that account is my mother's Social Security and my dad's pension that was left to her. I put nothing in that account at all. You'll never see me with anything in there.
Let's talk about that. Those are exempt from garnishment. Social Security and most pensions are exempt from garnishment. So if they were garnishing them from her, she would have an objection saying it's exempt because it's my Social Security and there's no other money that goes in there. Now, if you put other money in there, it poisons it.
I don't believe that. Sorry.
So let's assume your mother has money in there that she gets from Social Security. And she sells a car. She puts that money in there. It makes it all not subject to garnishment. Or you put some of your money in there that you get from babysitting, or you had a garage sale or something and you put money in there. It taints it and it becomes subject to garnishment. So I don't know any of that other than what you're telling me. There's no affidavit from the bank. There's no nothing that says this is exempt. So this is harsh. Your mother put you on there to help, and all of a sudden the bank takes the money for you to pay a debt that's been unpaid for more than 7 years. And this happens several times a year. So, all right, no proof of the source of the funds other than what you said.
Could I be given time to get that proof? I've never done this. I wasn't aware that I needed that.
And you shouldn't be ashamed of that. You're not a lawyer. You're a person. And people, I just had some people that just got sued. You heard it. We didn't know we were supposed to show up for the trial. That's not much of a defense to a default, but they were so unknowledgeable. They didn't even know they were supposed to be there for the trial. All right, not listed exemption and interested party is the mother. Ms. Bauer, is this the kind of case that legal aid might get involved in?
Yeah, that's a great question, Judge. Potentially, we would have a similar, probably I'll say standing issue, but it would probably be the mother that would need to contact us, but I'm happy to speak with Ms. Doyle about coordinating that, absolutely.
Your Honor, could I interject for a moment?
Yes, just let me ask one question. What's
Sure.
your mother's name?
Bonnie Slotman. I can spell that if you, I know it sounds difficult, but
Slaughtman.
SCHLAUTMANN.
SCHLAUTCH.
MAN.
Schlautman. And your father's name?
Douglas Slotman.
And they were both on that account?
Before he passed, yes, I believe so.
When did he die?
July 15th, 2003.
2003?
Yes.
All right, so it's just Bonnie Schlautman. All right, Mr. Goodman, what's your thought here?
The judge, whenever we get an objection to garnishment and there's allegations of exempt funds being held, we obviously take that seriously, and we have a subpoena that we send to the bank that basically says, hey, we need this information right away, because if there is in fact exempt funds, we release it. We don't wait for the judge. We'll just prepare a garnishment release and we'll release it. And that's just standard operating procedure for our office. And so we did that in this particular case, Judge. And so this garnishment was issued on May 9th and served a couple days later. We sent out the subpoena, and I just got back the results. And so I've got bank statements from, it looks like March, April, May 2025. And I don't see any Social Security money deposited in the account, not once. I see a Pepperco US payroll.
That's not the right account. That's not the account you took it out of. The Pepperco payroll would be my husband's account, me and my husband's account, and that would be Ken Doyle and Kathy Doyle. You took it out of the account that was Bonnie Slotman and Kathy Doyle.
Okay, well, the bank.
I think there was a mistake made there, because my husband's payroll absolutely does not go into the account that you took the money out of.
Okay, so, I think what the bank does is when your name was on both accounts, your account with your husband and also an account with your mother?
Correct.
So, Judge, we sent the subpoena, and we see all kinds of deposits coming in from payroll companies. We see deposits there's a lot of checks coming in from MGM Grand. There's.
Yes, that is our personal account.
So,
that's not the account with
all
my
right,
mother.
so either you're mistaken or they are. That account is garnishable. Your husband's account that you're on, that has his paycheck and your casino winnings put in there,
yes, sir,
is garnishable.
Yes.
So the only reason we think your mother's account was garnished is because you said so.
I can give you the proof if you give me time.
Garnished the account, and obviously I don't want to put the account numbers out here over the internet live stream, but I'm not sure your defense is even correct. It may be they just took the money out of your account.
May I speak, please?
Yes.
So I have my mom has the bank statement that they took out of her account. I never had $6,000 in the account with my husband, so it's absolutely impossible for them to have taken that out of me and my husband's account. But I can, if given, a little time, 10 minutes, I could run over to my mom's and get that bank statement, and you could speak to my mother if you wanted as well.
I'm at an account. This account has the name of Kenneth Doyle and Kathy Doyle. It had $18,000 in the account.
No, it has never had $18,000 in the account.
I'm looking at the balance, the daily balance. On April 15th, 17,256. On April 28th, 16,878.
That is my mother's account. I think the bank has made a mistake.
Your Honor,
Honestly, I don't have that kind of money. We don't make that kind of money,
it's her burden of proof.
which
I
I
feel
didn't
that she has
realize.
failed to
But
establish
now that
that.
I know that it is my
All right,
burden of proof.
stop. Both can't talk at once.
Yes, sir.
All right, right now, the bank's holding the money until I tell them what to do with it. My recommendation is that your mother contact Meg Bauer. And in the meantime, Mr. Goodman's got to establish which account this was garnished from. If this was garnished from your account, congratulations. You've paid this debt in full and they'll give you a satisfaction of judgment.
Okay.
If it was garnished from your mother's account and it's exempt, your mother may have a defense. But I don't know. It seems like it'd be hard to make a mistake with file numbers and account numbers, but I'm gonna continue this.
I think where the mistake might have happened
Yes.
is that directly after the money was removed from my mother's account and I got the notification, the bank called me the very next day. Me and my mother went up to the bank and removed me from her account so that that can't happen again. So when he did his inquiry, I'm assuming, I don't know for sure, it probably only pulled up me and my husband's bank account. But there's never been $18,000. So I don't know if they're combined or what happened there, but I would like the opportunity to prove
All
my
right, we'll see
case.
if we can sort it out. And what you did was prudent. Take your name off your mother's account, whether it's exempt or not. All right, this is gonna take a bit to unscramble it. And like I said, they set these just because we don't have enough hours in the day and a landlord-tenant day, and it always is a stressful circumstance for me. In the meantime, you've apparently made zero attempt in 7 years to pay on this debt. No attempt at paying plan. So, as I said, they're good for 10 years. We're gonna have to go a ways to put this.
And like I said in my appeal, I'm not opposed. I can make payments. I can't afford to pay it all at once.
I would indicate for the court that the disclosure does not identify which account the funds came from. But when we got the subpoena, looking at it closely right now, that's right. They provided they provided bank accounts to both of them. And the reason they probably didn't, they didn't need to identify because Miss Doyle's name was on both accounts. She was on the account with her husband. She was also on the account with her mother. Where they grab it from doesn't matter. She was an owner of several accounts, and one of them had clearly close to $18,000 on it when the garnishment was served.
It wasn't my money.
To further complicate things, let's assume they took 2,000 from her account and 4,000 from their mother's account. Whatever was taken out of her account jointly with her husband is garnishable.
And I have no problem with that.
And so we'll have to sort this out, but I'm going to continue it to August 11th. (2025) at 9:30 to 10:30. Does that work for you, Mr. Goodman?
Yes, Your Honor. We'll make it work.
In the meantime, I'm going to put you in what's called a breakout room where you can talk with the attorney from legal aid and your mother can contact her. In the meantime, Mr. Goodman's going to try to get a breakdown of what was seized from which account. And then there's also an issue of whether your mother's account is exempt. So there's a lot going on here. All right, Miss Doyle, is your mother's not there, but
No.
we'll give the money or the information where she can contact legal aid. In the meantime, your mother doesn't have her money; it's frozen by the bank.
Correct.
And if she had $18,000 in it, apparently she's got some other operating capital. So we'll sort this out. All right, Mr. Goodman, thank you for your efforts on this. You're good at this. Let's see what we can sort out from the bank and maybe make an informed decision on August 11th.
Judge, I heard that you wanted me to try and understand how much money came from which account, which I'm happy to
Yes.
find out from the bank. Is there anything else you need from me?
Yes, if Mrs. Schlotman's account is in fact exempt, or whether it's got other funds commingled with any social security or other sources of income.
All right, and would you like me to supplement our response with these bank records? Would you like to see those and have those in your hand for this August 11th
Yes,
hearing?
that would be helpful.
Okay, we'll do that.
All right, thank you. You're both good to go.
Thank you.
Judge, you're gonna put her in a,
Oh, yes, let me put you in the break dancing room.
And Ms. Doyle, if you'd like to work something out with me, don't hesitate to call my office and talk to
I
me,
would-
okay?
I would love to work something out with you.
Okay,
We can
Thank you,
pursue
Judge.
that. All right, thank you.
Let's get the facts straight. She loves a verbal ashtray. Never blowing smoke when she gets pissed. She's quick to castrate. Love her on a good day, love her on a bad day. Either way, she's here to stay, stay, stay. Call her